Item 54, motion 10 regarding children's rights and marriage law. I'd like to welcome Minister O'Dowd to the House. Can I call on Senator Bacik to move the motion?
I'm delighted to move this motion and to welcome the Minister to the House. I know you're here in place of Minister Fitzgerald, and I'd like to thank both you and Minister Fitzgerald, and indeed Minister Burton, for indicating that the Government will be accepting the motion which I'm proposing on behalf of the Labour Senators Group. And I'm really delighted that Senator Van Turnhout will be seconding the motion, so it's genuinely a cross-party and cross-house effort between Labour and Independents. But this motion is about an issue which hasn't been of enormous public concern to date in Ireland, but has become an increasingly serious issue in other countries. And I'm grateful, I must say, to the Labour Women Group and to Mary Flynn in particular, who brought the issue to my attention some months ago on foot of a motion that Labour Women had put to a Labour Party conference some years ago on this topic. So the motion is about the legal minimum age at which persons may get married. And thus it's also about the practice, the different but overlapping practices of child marriage and of forced marriage. Although these are separate, as I say, there's overlap. Child marriage is where one or both parties to a marriage is legally a child, that is under 18, and of course forced marriage is a marriage in which one or both parties is married against their consent or their free will, and of course that can occur where one or both parties is over 18. But clearly it's much more likely that a person's will could be overborne when they're not regarded as an adult in law, and that's where we do have overlap. A child is much more susceptible to influence and has much fewer legal rights to assert. And for these reasons, international conventions thus acknowledge the need both to ensure protection against forced marriage and to ensure protection of children within any law on marriage. So the right to marry in the UN Universal Declaration of Human Rights in Article 16 is reserved to men and women of full age. Article 16(2) says that marriage should only be entered with free and full consent. The 1962 UN Convention on Consent to Marriage and Minimum Age of Marriage provides in Article 2 that state parties shall take legislative action to specify a minimum age for marriage, and no marriage shall be legally entered into by any person under the age except where a competent authority has granted dispensation as to age for serious reasons in the interest of the intending spouses. And indeed, the CEDAW Convention on the Elimination of Discrimination Against Women prohibits child marriage in Article 16(2). And UN reports show that since 1994, and more than 150, the UNFPA says, more than 158 countries have passed legislation raising the minimum age of marriage to the age of adulthood, that is 18, albeit that many do allow exemptions on court application. So we have near universal commitments to tackle both the practice of forced marriage and to end child marriage. Nonetheless, we see very high levels of underage marriage, of child marriage, particularly in developing countries. And indeed, this issue has also been highlighted in many developed countries. Now, Senator Van Turnhout will speak more on the international context, and particularly the child protection context internationally. But I just wanted to mention certain recent legal developments in Britain before I turn to examine Irish law in more detail. So in Britain, the prevalence of forced marriages and public concern about this has become a real issue. In 2013, the UK government's forced marriage unit dealt with 1,302 cases, in which 82% of victims were female and 15% were under the age of 15. And the cases involved communities from 74 different countries. In response to the problem, we've seen two recent legislative changes in Britain. One, the Forced Marriage Civil Protection Act in 2007, allowing the courts to issue forced marriage protection orders in order to protect individuals who are being coerced into marriage. And then just this year, the passage of the Antisocial Behaviour, Crime and Policing Act 2014. Among its provisions is one which makes it a crime in England and Wales to force someone to marry, with a maximum penalty of 5 years imprisonment. We have a very well-known charity called Freedom Charity, set up by Anita Prem, which educates young people in Britain about forced marriage, which has been pushing for this and has been very approving of this law. So, what about in Ireland? Well, there's been, as I say, no real public debate on this issue, on the issue of either child marriage or forced marriage. To my knowledge, this is the first debate on the issue in either House of the Oireachtas, so I'm really delighted that Seanad is leading on this. And Senator Van Turnhout did raise it previously in a debate here, and I had previously raised it with the Minister, but I think this is the first full debate we've had. We haven't passed any specific law concerning forced marriages, and we still allow marriage where one or both parties are under 18 on a court application for an exemption. There is no provision in our law for any sort of child protection order to be made, or indeed any contact with child welfare agencies where such an application for an exemption is made. Of course, we do have laws prohibiting coercion. At common law, indeed, a marriage is a nullity if one or both parties has been forced or coerced into it. The relevant legislation to which this motion refers is the Family Law Act 1995 and the Civil Registration Act 2004. Section 31 of the Family Law Act 95 provides the minimum legal age at which people can get married in Ireland is 18. But Section 33 allows application to the court for an exemption from this rule where one or both parties are under 18. And Section 2.2 of the Civil Registration Act 2004 has maintained the facility in Section 33 to apply for the exemption. So relatively recent law still maintains this facility. But we are concerned, both Senator Van Turnhout and us in the Labour Senators Group, that keeping this exemption in place may facilitate the practice of forced marriages. It may lead to young girls in particular, but also boys indeed, being coerced into entering marriages. And we put forward the motion in the context of a desire to protect the welfare of children and indeed to ensure that in particular that women and girls are protected. And thus we argue the state should consider whether to remove or amend the statutory provision and thereby ensure robust enforcement and adherence to the minimum age of 18. Our concern is, in particular, that the exemption facility provided in Section 33 offers no protection for minors. Just to look at the practicality of it, Minister, applications for exemptions are made to the Circuit Court. They're made in private. There's no public record of them. There are no guidelines on the criteria for granting the exemption, and there is no provision for the minors themselves to be legally represented at the hearing, or indeed for the HSE or Child Protection Authorities to be notified. Now, the Oireachtas Library and Research Service has produced a very helpful note which tells us that in 2012, according to CSO data, there were 28 marriages registered in Ireland where either the groom or bride or both were under 18. In 21 of the marriages registered, the bride was 16 or 17 and the groom was 18 or over. The Minister's own note tells us that between 2004 and 2013, almost 400 parties to a marriage were under the age of 19. So clearly this is an issue in Ireland. Section 33 is being used because one of the unknowns as we commenced the investigation into this was whether in fact it is an issue. But clearly it is an issue. We don't know the circumstances of the 28 cases, but we do know that children are getting married in accordance with this exemption in Ireland, and we know very little more about it. We have, however, a High Court judgment, which unfortunately is unpublished, but which was reported on by RTE on 18th of June 2013, so just last year, in which Judgment Meneman in the High Court was dealing with an application for an annulment of what he described as an arranged marriage, and he annulled the marriage which had been contracted between a 16-year-old girl and a 29-year-old man. But in his judgment, as RTE reports it, he said that in certain circumstances the provision for marriage exemptions may give rise to significant child welfare issues. He commented that legislation may be needed to assist young people who are placed in arranged or forced marriages, and that the system for seeking exemptions from the legal age limit for marriage requires review, as it raises child welfare questions in certain cases. And in particular, he said, the question arises as to whether the Circuit Court, when asked to hear an application under Section 33, and we know that at least in 2012 there were 28 such applications, or there must have been, giving rise to those 28 marriages, that at the very least the Circuit Court should be obliged to give notice to the HSE to inquire into the protection and welfare circumstances of the child in respect of whom an exemption from marriage age is being sought. Now, I must say in the particular case at issue there were very serious child protection concerns, and the child concerned had been, I think, in care, but the judge commented that the state agencies had behaved appropriately at all times. However, he was critical really of the indirectly, I suppose, of the legislature for failing to ensure that there's protection measures put in place where applications of this sort are made. So really it's in the light of that case, it's in the light of the concerns that have been raised with me by Labour women and with Senator Van Turnhout on the child protection side that we wanted to bring this issue to the fore, and really to seek to preempt any sort of abuses of the rights of children that may occur in Ireland in the future, and that we've seen occur, as I say, even in our neighbouring jurisdiction, and certainly in other developed and developing countries worldwide. Clearly, it is a difficult area because even if we amend or abolish the facility to apply for an exemption in Section 33 of the 1995 Act, we still do have an issue about the problem of coerced or forced marriage for those who are over 18. And I think we should then consider legislating to ensure that it is a crime to force anyone, even someone over 18, into marriage. So in other words, to follow the British model. I think we do also have to just consider And I anticipate the Minister will be establishing an interdepartmental group on foot of this motion to consider this issue. But that group, I think, will need to consider age limits generally. I mean, it may seem somewhat inconsistent when the Constitutional Convention has recommended lowering the voting age to 16, when the recent Oireachtas Committee on Education and Social Protection recommends an age of 16 for young people who wish to register a change of gender. But I think it is entirely consistent with child protection to say that we can consider lowering voting age, we can consider allowing people to register a change of gender at a slightly younger age. And indeed, in our 1997 Non-Fatal Offences Against the Person Act, a child at 16 can consent to medical treatment. So I think that's entirely consistent. Those are decisions just affecting that child. They're decisions I think we can allow a child to make and recognise their own autonomy. But I think a marriage is different. It's a contract legally between two parties. And I think it therefore involves particular issues and concerns around coercion, which don't arise where we're talking about a minor making a decision, for example, on how to vote. So I think it's appropriate in the context of concerns about forced marriage worldwide and in the context of the international conventions that I've referred to and international issues generally, that we would look to keep a line under the legal minimum age of marriage at 18. I think that it's been, I suppose, many years ago in Ireland, it would have been the norm perhaps for people to get married much younger. We see now average marriage age is moving well above the legal minimum of 18, and I think again we'd seek to preserve and protect childhood. I know that many people fought very hard to ensure that 18 would be the age up to which young people would receive protections, for example, within the criminal justice system and so on. So I think it's appropriate that in our marriage law too, we would regard 18 as the legal minimum age at which a person may enter a legal contract of marriage. Thank you, Minister.
Senator Van Turnhout.
Thank you very much. Minister, you're very welcome to the House, and I'd like to thank Ivana, who, like